state laws, types of guardianship, appointing a guardian, liability, that's always a question, removal and termination of a guardian, and alternatives. So loaded agenda. So guardianship is a legal relationship between a capable adult, the guardian, and a ward, the protected person, the person for whom guardianship is obtained. In most states, the law presumes that individuals over the age of 18 can make their own decisions about what is best for them in their daily lives. Some may feel that it is necessary to apply for guardianship to protect their loved one who has special needs. Some of the terms involved: protected person, an individual for whom guardianship is sought; petitioner, the person who files the initiating forms to begin the guardianship process, most often the parent or grandparent seeking guardianship; the respondent, that's the person for whom guardianship is being sought, otherwise known as the protected person or the ward; guardian or conservator, the person appointed by the court to handle the protected person's affairs. So guardian typically generically refers to guardianship of the person, and conservator typically addresses financial issues, if you see those two terms. So limited guardian means you don't have both. So if there's a limited guardianship, then the guardianship is typically over one of the two, either guardian of the person or guardian of the estate, otherwise known as conservator. So when you go to court to obtain guardianship, and in most cases it is at age 18 or older, because parents that have not relinquished their parental rights rarely need to go to court for guardianship prior to their child turning age 18. It does happen, and when it does happen, most often it's because they have come into assets. So a minor has received a settlement from a litigation situation, be it malpractice, personal injury liability, or let's see, manufacturer liability, personal injury, or malpractice, one of the three. And so if they have received a settlement and they're a minor, then they can't handle funds because they're not of age. So a parent or parents will need to go to court in most cases to assume responsibility for their estate or be the conservator. Otherwise, guardianship usually is at age 18. Now, on occasion, I've heard people be told, don't wait until 18, get into court early when they're 16 or they're 17. And while a parent may be able to do that, please understand that just as there is a difference between a minor drawing SSI versus one 18 or older, there is a difference between guardianship of a minor versus guardianship of an adult. And so I would, except in unusual circumstances, I would discourage rushing into court to get guardianship before they're 18, because the court is going to be granting guardianship of a minor, not an adult, and you will likely have to go back to court because there are different implications of the court granting guardianship for someone 18 or over. Under age 18, their rights are not being stripped because they're not of age to have the rights anyway. And therefore, in most cases, guardian for a minor does not roll forward into guardian for an adult without going back to court, additional legal expense, hassle, etc. So if you're looking at a standard situation, a person that hasn't inherited, a minor who has not inherited, and you're the parent, then in most cases, it will be upon their turning age 18 that you will petition the court and go before the judge to have guardianship granted. Guardianship proceedings vary depending upon what state you're in. We'll mostly talk about Indiana this evening, but we will touch on Kentucky because there have been some substantial changes in Kentucky in recent years that are worth talking about. Okay, trustee at the bottom, given powers of administration of property in a trust property with a legal obligation to administer the trust according to the trust document. So in my practice, I manage tens of millions of dollars of trust funds for individuals with disabilities, so a lot of trust accounts. And so we're working with trustees every day. In fact, not more than 10 minutes before I hopped on to the workshop this evening, I was responding to an email where a because of the disability, a doctor has recommended that there be the installation of a pool or hot tub or sauna or something similar to that at the home. And so we are looking to the trust to assist with the expense of installing that now that we have medical documentation that it is in the interest of the trust beneficiary. So trust accounts are often invested. And so if we're going to have a substantial expense like that in the thousands of dollars, then we'll need to make portfolio changes so that funds are liquid and they can be available to pay for the contractors that are going to come in to make that addition to their home. So that's an example of how things work with a trustee. So you have a trust document, then you have a trustee who's in charge of whatever the trust holds, and understand that a trust can hold whatever typically a person can: a house, an automobile, financial assets, land, pretty much you name it. And then the trustee is the person that is responsible for whatever the trust owns. The trust beneficiary is the person that is to receive the beneficial interest of whatever is in the trust. And then myself, I would be an advisor handling assets of the trust and helping to guide the trustee. So it's a team effort, and we make sure that first and foremost, trust beneficiaries are well served. Okay, so guardianship varies by state. So in Indiana, we've had the change recently of assisted decision-making. And so we have almost like ordering off of a menu, we have different flavors as it relates to guardianship here in Indiana. In Indiana, we have full guardianship, which is guardianship of the person and guardianship of the estate or conservator. We have partial guardianship, where the ward or protected person has no assets, in which case you would, in most cases, simply secure guardianship of the person. And then we have supported decision-making, which is an alternative to guardianship. And that's where a person designates an individual to assist them in making decisions, but they are ultimately still in charge of their situation. And then, as you'll see later, there's also, when the individual with special needs has capacity, there's some other alternatives as well. And we'll talk about those later on. So an example of how things vary is Indiana versus Kentucky. Now, in Indiana, if you are going to pursue guardianship, then typically you start by consulting with legal counsel, that is a family law or a special needs attorney that can assist you with what's involved with guardianship, the pros and cons, the appropriateness of it, the expense of it, what's involved with it, and so forth. Then, if you do decide to proceed with guardianship, a petition is put together, and that includes medical evidentiary from their primary care physician or specialist, but definitely an MD, that speaks to the nature of their disability or special needs, and therefore the appropriateness of securing guardianship. So the paperwork, including the medical information, is then submitted to your county court. So counties all over the state of Indiana receive these petitions on a daily basis. And the objective of putting this petition together and submitting it to the county court is to result in a hearing. So depending upon the county, sometimes these hearings are once a week, twice a week, it just varies. The larger the metropolitan area, such as Indianapolis or perhaps Evansville or Fort Wayne, et cetera, the more structured they are, the more systematic they are with regards to when certain hearings are held and on what days and what color the paper is that you submit the paperwork on, and how the I's are dotted and T's are crossed. The more you're out in the hitherlands, shall we say, the more flexible things typically run. Now, what they're referencing here with Kentucky is interesting. Many of you may not be aware, but up until just a few years ago in the state of Kentucky, if you were going to petition your county court for the purposes of having a guardianship hearing scheduled, Kentucky impaneled a jury. So if you wanted guardianship over your son or your daughter with special needs, then the county court would actually impanel a jury, and the jury would hear the pros and cons of the guardianship as it would relate to your dependent, and they would weigh in on the guardianship proceedings. And it was quite unnerving in some situations to, shall we say, air your family laundry in front of a group of your peers. So in 2018, Kentucky joined the majority of the other states in the country in dispensing with the jury, impaneling a jury. And now in the case of Kentucky, as long as it is not contested, if it's contested, then a jury can be impaneled. But of course, most guardianships are not contested. And we'll talk in a little bit about when it is contested and what does that mean and so forth. But in Kentucky now, in most cases, there is not a jury. The judge orders the guardianship from the bench, as we do in Indiana. Okay, there is full guardianship, as we discussed, limited guardianship, and then joint. So I was on a workshop last night and I was asked, does one person go to court to get guardianship? Do two people or three people, or how is that determined? Well, most often joint means there are two parents. They could be adoptive parents, they could be biological parents, they could be custodial parents. But when we say joint, usually it's the two parents. It doesn't have to be, though. We do sometimes see a situation where if there is a single parent or a situation where we have a widow or widower parent, they will sometimes go to court and obtain guardianship along with an adult sibling of the child with special needs. So a mother-daughter, a mother-son, a father-son, father-daughter, whatever combination can be joint guardians. It doesn't have to be the same generation. It can be a combination of generations of parent and adult sibling of the child with special needs. Now that begs another question, because people said, so then if you have joint guardians, what happens if something happens to one of the guardians? And the answer is almost without exception, the remaining guardian would provide the court with proof of death of their co-guardian, and then they would assume alone the responsibility of being guardian for the ward or protected person. So in that situation, you kind of have a succession plan already planned, because one does not have to go back to court. You simply have to submit proof that your co-guardian has passed, and then you can continue on as the sole guardian. The reason for that is because to be a joint guardian, both guardians appear at the guardianship proceedings, and therefore the court's already said grace or has given their blessing to those two individuals being guardian. Now, if we have one guardian and that guardian dies or becomes incapacitated and they're unable to perform their guardianship duties, then someone will have to go to court to take their place. And in the event of death, of course, we have a will that a person can execute indicating who they want to follow them as guardian. That's extremely helpful, but please understand, simply designating who is to follow you as guardian in your will not suffice for the court. So whoever is designated would go to court with the will, petition the court, in other words, to become the guardian, and then the court would look at the will and would attempt to honor the wishes of the deceased unless there's a perfunctory of evidence as to why they shouldn't. So if you have two parents that are joint guardians and one of the parents dies, now we have a sole guardian that's left. It may be wise in some situations to consider that sole parent that's left as guardian actually going to court and adding an adult sibling of the child with special needs, a niece, a nephew, or whoever they would otherwise list in their will to take over when something happens to them before they die or become incapacitated. That is almost like my wife says, when the tank's down to half empty, you fill it up. So it's kind of like when you've lost one of your two guardians, so you're half of where you were, it could be a trigger to decide, let's just go on to court and get that other joint guardian put back in place. And then you won't have to worry about, upon death, whoever is designated in the will having to return to court at that point. Again, I invite you to ask questions. You can unmute yourself. You can put something in chat, whatever works for you. And we'll try our best to answer the questions. Okay, This is a bit of administration, and we're not going to spend a lot of time on this. Suffice to say, there's paperwork, there's a paper trail. Although Indiana has gone to electronic filing of petitions and so forth, we're trying to get into the modern age, shall we say? But there's a process, there are forms, there's paperwork. Okay, the forms are filed. County Attorney's Office reviews the petition, determines whether the case will proceed. If the case will proceed, then the court will appoint an attorney for the respondent, and that is for the ward, to represent them throughout the process and advocate for their best interest, otherwise known as a guardian ad litem. Again, just depending upon where you're located, some things are more formal, others not. The court will schedule a hearing typically within 60 days of the petition being filed. So in almost without exception, 90 days is enough to get through the guardianship process, because the hearing is usually scheduled within 4 to 6 weeks. It's a matter of what time it takes to get the petition together and to get on the docket at the court. The court will appoint a team where appropriate to determine if the guardianship is appropriate, because the court is actually advocating for the ward or the protected person. They want to make certain that appointing the individual who has petitioned the court as guardian is in their best interest. Okay, so you go to court, the judge hears the case. In most cases, you're in and out of the courthouse in under an hour. It usually does not take long. So appointing a guardian requires proof to the court that the person is not able to care for him or herself. Meaning, just because someone wants to become a guardian is not enough. The court needs to be convinced that it's appropriate for the ward or protected person. That's, again, you need the physician's certificate, and in some cases, state agencies are included. Okay. Court appoints someone to represent the individual, typically considered a guardian ad litem, and it depends upon what county, again, that you're in. Okay, the liability issue. A guardian must use reasonable care and caution when making decisions. Unless a guardian acts actually negligently, unreasonably, irresponsibly, a guardian is generally not personally liable for the actions taken by the protected person. So what does that mean? That means if the ward or protected person is involved in criminal activity, that does not mean that the guardian is liable. That's a concern sometimes if we have a protected person or ward whose behavior may not be always predictable. So that's a consideration. Again, guardian is not liable, is not assumed to be an accomplice in whatever activity may draw negative results or reactions. The guardian may be held liable if his or her actions or where the person's property is damaged due to careless acts of the guardian. So it's common sense stuff. If the guardian is acting with reasonable prudence, they should be fine. Okay, removal of guardian. A guardian may be removed by the court if they are not properly performing their duties. Now, keep in mind that there is a reporting process with guardianship. So you obtain guardianship, you have a court order. That paper is something that you want to get in a file and protect because it'll be handy to have it in a lot of situations. Some people laminate it, carry it with them, get a shrunk copy of it, or just kind of have it with them all the time. You just never know when it's going to be handy in a medical situation or otherwise. Successor guardian may be appointed if the first guardian resigns or dies, as we previously discussed. Now, termination of guardian also occurs in some situations. One can be when the individual is 18. So when the ward or protected person, as we were discussing earlier, reaches 18, if guardianship was obtained as a minor, it terminates. That's what prompts the need to go back to court. That's why parents should be cautious about obtaining guardianship before age 18. They may end up having to do it twice. The protected person marries before age 18. So I think it's legal to get married before 18 and in many states. And so if they do that, that undermines the guardianship. Once they're 18 and you have guardianship of them as an adult, then they would only be able to marry with the blessing or approval of the guardian. It's different under the age of 18. There you have a little bit of a gap. They're not of age for all legal rights, but they can be old enough to marry. So just kind of want to watch that situation. The protected person is no longer incapacitated, meaning the reason for guardianship is no more. The protected person dies. In the case of guardianship of the property, the estate is exhausted, meaning there's nothing to be guardian over. The funds are gone. They've been depleted. The protected person's residence changes to another state and a guardian has been appointed in that state. So let's pause there for a moment because questions had already come up before we started this evening's workshop about state-to-state issues. So guardianship is granted by the county court, but it is representative of the state in which the individual resides. So if guardianship is granted in Vigo County, it would work in Wayne County. However, when a person moves out of state, in that situation, because laws regarding guardianship vary by state, if the ward or protected person, not the person serving as guardian, but if the ward or protected person moves to another state and stays there, meaning they have relocated, it wasn't for a week at the lake or a month with their, staying with their grandparent or something, they physically have moved, they're not coming back, then the guardianship needs to be transferred. And so typically an attorney in the state the guardianship was presently arranged for, and guardianship in the new state. So you need an attorney typically in both states. So the attorney in the old state files to release the guardianship, and then that release is then forwarded to the respective court in the new state so that the new state of residence can appoint a new guardian, and it can be the same person. But nevertheless, if we do have a change in states after a period of time, you want to make sure you're really going to settle there and not go back, then the guardianship does need to be transferred to the new respective state. And then the guardian is subject to the reporting requirements of the new state that's then holding the guardianship. Now, in most cases, these guardianships have an attorney attached to them. Most of the time, it's the person that assisted with the guardianship to begin with. And so the guardian or the attorney in the new state that is filing for the guardianship of the old state to be replaced would be the attorney then associated with the new guardianship. So that's how that works. Now, another question came up. We'll deal with the state-to-state issue at the same time. And I think that question had to do with some government benefits. So please understand, if the guardian, if the protected person or the ward moves from one state to another, it does affect government benefits. Of course, what immediately comes to mind are Medicaid waivers. And you want to be careful about moving from Indiana to Kentucky because Kentucky has a different waiver system. And for individuals with developmental or intellectual disabilities, the waiver of choice is what's called the Michelle P. waiver in the state of Kentucky. And at least for now, the wait for that waiver is about 10 years. And so you can't establish residence in Kentucky, transfer guardianship to Kentucky, and then expect to continue to enjoy benefits of an Indiana waiver, such as the family supports waiver or the much sought after community integration habilitation waiver. So you got to be kind of careful about switching state lines, because one can literally lose their Medicaid waiver and go from being on a waiver to being on a waiting list. Now, whether preferential treatment would be given or not depends upon how much of a crisis you're in. No state, family services department wants to be in the evening news. But as far as routine situations are concerned, one can be put in a substantial disadvantaged situation as a result of changing states. On the other hand, we do have people that have moved from Kentucky to Indiana with a wait of only 6 to 8 months for the family supports waiver. We have had people move. Now, what's interesting is prior to September of 2012, about 9 years ago, Indiana had that long wait situation going. with something called the support services waiver, the autism and the developmental disabilities waiver. Long waits. And we had people moving from Indiana to Kentucky. So it's kind of interesting depending upon, who's being most generous with benefits, et cetera. People have literally moved back and forth and so forth. But so keep that in mind. Now, to continue with the state-to-state theme, because another question came up, and that was, if something happens to a parent and the protected person becomes, the guardian for that protected person becomes the successor guardian, then whose benefits do they draw off of? Well, the answer is it depends. First of all, if a parent dies, then the protected person or the individual with special needs is in most cases going to draw survivor benefits off of the parent. That's in many cases a fairly rich benefit. It can be as much as 75% of that person's full retirement age Social Security benefit. And so we're seeing survivor benefits certainly well in excess of $1,000, even in excess of $1,500 per month. So that's one consideration. There are some cases where an individual with special needs could draw off of a step parent if the step parent is the custodial parent and the individual with special needs is financially dependent upon them. So those are kind of the considerations. But an individual can draw off of a biological parent, an adoptive parent, or as I said, a step custodial parent. It just depends upon the situation. Of course, parents or family is always advocating for the individual and wants or seeks to get them connected with the largest Social Security benefit record. And sometimes it works out quite well. Well, that was my attempt to answer a number of guardianship questions that had come up as we were starting the call. If I missed the mark, then if the individual that asked those questions would be so kind to unmute and give me an opportunity to address any additional questions related to that.
Gordon?
Yes.
My name is Ann. I'm going to jump in. I have guardianship of my 22-year-old son, and I have an 11-year-old autistic son. Would I be able to become guardianship to both of them?
Okay. So if you're guardian to a 22-year-old, you, I assume, went to court to obtain that, yes?
Yes.
Okay. And are you the sole guardian of the 22-year-old, or do you share guardianship with another parent?
I am the sole guardianship of the 22-year-old.
Okay. I'm taking it there might be a different parent involved with the 11-year-old.
Yes.
Okay. So in the case of the 22-year-old, it's settled. You're the sole guardian. Someone had to be, of course, subject to notification process for that guardianship to be granted by the respective court, but that was granted. Now, I will mention this to you because just because the other assume biological or adoptive parent signed off letting you be the sole guardian, that does not prevent the 22-year-old from in the future drawing off of their biological father, in this case, we will assume Social Security record. So just because you're the sole guardian does not prevent your 22-year-old from drawing off of dad, is what I'm saying, at the time dad becomes disabled, draws Social Security retirement, or dies. I have a situation right now in northern Indiana where the father lived in Tennessee and had little to nothing to do with the 20-something, now 18-ish year old son with special needs, and the father passed. So we are in the process of transitioning basically from SSI to adult child benefit survivor benefits off of the Social Security record of the deceased parent, even though that deceased parent had little to do with the child with special needs for most of the 18 years that have passed. So that's kind of an interesting tidbit. Now let's move on to the 11-year-old. So in the case of an 11-year-old, usually you don't go to court. Usually it's either a shared custody situation, or you're the custodial parent and the other parent's making some child support payments, etc. Now, does the 11-year-old receive SSI?
He does receive SSI, and I am married to his husband or his father, so we're still living together.
Oh, okay, fine. All right. So in that case, there's no child support for the 11-year-old, correct?
Correct.
Okay. So what will happen is if you determine it's appropriate when the 11-year-old reaches age 18, because of special needs, then you would basically repeat the process, but presumably on a co-guardianship basis with the 11-year-old, then 18-year-old's father.
Okay.
So you can be the sole guardian for one and joint guardian for another.
Okay.
Was that enough?
Yes, thank you.
Okay, yep, certainly. All right. Okay, so then we've got a variety of situations where guardianship would be terminated. Okay, let's move on. Alternatives to guardianship, options, as you
Hey,
see.
Gordon,
Yes.
there was another question in the chat. There was
Okay.
another question in the chat if you want
Yep.
to address that real quick.
Okay, let me get to that. I'll flip over here.
Sure, sorry about that.
Nope, it's wonderful. It is great. Chat, here we go. Okay. I am sole guardian of 3 family members. Due to stress, I attempted to give up guardianship, but the judge refused to grant my request. Boy, that was a fun judge, huh? Saying I had to find a replacement guardian before he would grant my request. What are my options? Okay. Well, so the first question would be whether these 3 individuals are minors or not. If the 3 family members are minors, meaning they are children of some other family member, and you've become the guardian because that family member died, became disabled, basically lost the kids, you stepped up for them, etc. Then in
Gordon?
Yes.
Hi, my name is Tammy, and that was my question.
Okay.
The 3 individuals, it's actually it's my sister, her
Mhm.
husband, and their son, all of whom are adults.
Wow. God love you. Bless your heart. Okay, bless your heart. All right. Well, so are they in Indiana?
Yes, and they're all receiving the CIH waiver.
Boy, you read my mind on that one.
Yep.
Well, it sounds like you're getting about all the help that you can muster. Are there 3 living with you?
No, I have them. Well, they did at one point, but they are living in 2 separate households. They all 3 have 24-hour staff. So I mean, I don't want to come across like I'm not grateful for all the help, because
Sure.
I am, from the bottom of my heart, so grateful for all the help. But it's still a tremendous amount of work, and I work full time and
Mhm.
try to have a life of my own, and it's not easy. So yeah, I just I feel sometimes, being honest, I just feel very trapped, and I'm not getting any younger. And so I just wonder if this is, I just sort of feel like this is going to be on me until the day I drop dead.
Okay, all right. Well, first of all, Tammy, I want to recognize you for being brave for 2 reasons, which may sound odd. One reason is being brave to step up for the family members who, by your being guardian, were unable to handle their own affairs. So that's first. Second of all, I want you to know that I recognize your bravery in being honest. And we need to be honest. I'm not going to say we have to be, but we need to be honest because by being honest and transparent, as you've been so kind to do for us, you help all of us to realize we're not superhuman. We're all human. And and to seek help. Because if we get pile driven into the ground, what good are we to anyone? And so, so I recognize you in that regard. A couple of things, and then we may want to, may be an appropriate time to mention that I provide a free follow-up consultation to families that are participating. And it certainly sounds like we could benefit from some individual time to discuss your situation. But one would be who's handling the Social Security funds. Because when they're in a waiver home like that, it can rub one of two ways, meaning you can be receiving the Social Security benefits and paying their bills, or it could be going direct to the provider. And so that may be a starting point for a conversation as to just how much control over their money you have, and therefore whether their potential may exist for getting additional help beyond that provided under the CIH waiver. So, but I want to help you. So, so hopefully that's enough encouragement to please sign up for the free follow-up consultation. It costs you nothing, but I want to do more than just kind of a quick 2-minute answer. Do you see what I mean?
I do. Thank you very much.
Yeah, and thank you again from several vantage points. And I truly have a great deal of compassion for your situation and want to help. So I know that Jamie, my parent advocate and relationship coordinator, will send a follow-up email Thursday. She's in next Thursday. When you receive that, please respond to her and let's get you scheduled. Are you Northern Indiana or Southern?
I'm in Indianapolis.
Okay, what a blessing. So we're close. We're 96 on the north side. So let's get something. Let's get you some help. Let's get you some help.
Thank you so much.
Yeah, absolutely. I had a mom in my office before COVID about 2 years ago, and she came in that situation. She was a single mom, brought her son with her, non-ambulatory, in a wheelchair, and she looked tired. And I asked her, I said, tell me about what help you're getting. There was no waiver. And her son was 24/7 care. And again, it's being honest. And I had to help her understand that being a caregiver it was not a sentence. It's okay. It's okay to cry uncle and ask for help and so forth. Okay, let's move on. Thank you so much for that. All right, alternatives to guardianship, and we're going to pop it back up here. Try to at least. There we go. Healthcare payee. So representative payee, that's a perfect segue from just what we were talking about, meaning who is receiving the Social Security benefits and so forth. That must have been a God thing. Oh, well. So representative payee is the person that typically receives the Social Security benefits. And by the way, I will mention this, just in the last couple of weeks, I've heard that some banks are putting people off, actually saying that there is a wait on setting up representative payee accounts. If any of you encounter that kind of situation, then shoot me an email, let me know it's not okay. And let us advocate for you in that situation. Representative payee, though, that role is changing because there was a time when we were talking hundreds of dollars. Now we're seeing Social Security benefits in some cases north of $1,500 a month. So the whole financial piece is kind of taking on a life of its own. There's healthcare representative, durable power of attorney, and these are where the individual has capacity. So where they have capacity and they can execute, they can understand what the document is and they can execute it, then an attorney can assist you in their executing these documents, which is power sharing. Not the same as guardianship. You do not have to go to court. It's relatively inexpensive. You might not pay more than $100, $150 per document for these types of things. So just a few $100s can get this done. But please understand it's power sharing, and they do need to have capacity to understand the nature of the document that they're signing. Also, a trust, of course, is for a conservator situation where a special needs trust could hold one's finances. And we'll talk about able accounts here in a moment, and then protective proceedings. Okay. The representative payee is the person authorized by Social Security to handle SSI or SSDI or a combination of both. And there needs to be some amount of record keeping. That's a question I'm frequently asked. No, you don't have to have a receipt for every dollar of Social Security money that's ever been spent. but there is an advantage to some amount of record keeping so that you can demonstrate that the funds were used for the protected person's benefit. Healthcare representative taking care of healthcare decisions. That's a document that they can sign if they have capacity. These are alternatives to guardianship. The same with the durable power of attorney. So healthcare directive is taking care of the healthcare decisions, and then durable power of attorney are financial decisions where you can assist signing checks, paying bills, and helping to handle their financial situation. If there's guardianship in place, you don't do both. These are, again, are alternatives to guardianship. In some cases, people may try a durable power and healthcare representative and may end up moving on to guardianship. So these are, again, different options. Okay, trust, a bit of a teaser for next week, because we are really going to get into special needs trust. But a trust is a relationship where the property is held by one party, the trustee, or it can be co-trustees. You can have more than one, or it can be an institutional trustee, like a bank, or a professional trustee, like an attorney. Lots of trustee options. So do not think that because you don't have a family member that's an MBA, that trust is not for you. Lots of options for who can be trustee, in addition to pool trust in Indiana, which is most often the ARC Master Trust. So lots of options. The trust is created by the owner, also called the settlor, trustor, grantor, the person that sets it up, in other words. That can be the same as trustee, or it can be different. The trustee holds that property for the trust beneficiaries. Special needs trust is a trust created for the benefit of a person with special needs. An S&T or special needs trust may receive assets such as inheritance, a court settlement, an insurance claim payment, a gift of money or life insurance proceeds, protect current or future government benefits, and pay for medical care, special equipment, education, entertainment, transportation, and more. All kinds of things that special needs trust can pay for or provide. There are different types of special needs trusts, and we're going to get into that next week. So look forward to a robust discussion about special needs trust, what you can spend it on, what you can't, what the trustee does, the tax implications of the special needs trust, and so forth. Protective proceedings, the court on request and without the appointment of a guardian may issue a protective order. So that's sometimes an option. Parental power, the parents of a minor may execute on behalf of minors consent waivers, power of attorney under the Internal Revenue Code. And that's guardianship. Very cool. Anything more on guardianship before we move to ABLE accounts? We're right on time, because we're going to need the remaining 35 minutes for ABLE. Okay, let me check the chat. Okay, and it looks like I think we're okay. All right, we've got a great group, almost 20 people this evening. Wonderful. Bless you for joining us. Thank you so much. All right, we have the ABLE Act up next. Again, our disclosure and a little overview. First of all, ABLE accounts, or the ABLE Act passed at the end of 2014, 2014. And what's interesting is it was renamed after the fact to the Stephen Beck Jr. Act. And that's because Mr. Beck championed the cause of ABLE accounts for 7 years. And on the eve of its passage in 2014, he passed away. So to honor him for his efforts, and he had a daughter with special needs, to honor him, they renamed the act in his namesake. This law allows eligible individuals with disabilities to have a tax-free savings account modeled after 529 college savings accounts. Legislation has been passed in most states. So most all states have ABLE accounts, and if they don't, they're using a neighboring state's account, etc. If you want to know the best website to go for information on ABLE accounts and the ABLE legislation in general, it's right there, www.able.nrc for National Resource Center.org. But that wasn't the end of ABLE accounts. In 2017, the Tax Cut and Jobs Act brought enhancements to ABLE accounts, and we'll talk about that this evening. Again, I invite you. We've got a lot to cover on ABLE, but if we're nearing the end and you sense we've not touched on what you had hoped we would talk about, then please unmute or put something in chat so that we can be thoughtful to answer questions. All right, so what does it take to be eligible for an ABLE? Because we've said it's tax-free. Wow. Meaning you put in after-tax dollars, it grows tax-free, it distributes tax-free, kind of taxed like a Roth IRA. So it has wonderful tax advantages. So,
Gordon,
yes.
I hate to interrupt, but were you planning to share a PowerPoint on the ABLE account?
Okay, I have it in front of me, but apparently I didn't reshare.
Nope, that's okay. That's all right.
Thank you.
Well,
Okay, so, okay, we're looking for the share. There we go. Okay. And let me see if there's been any new chats other than people trying to get my attention. Hello, where's the PowerPoint? Yes, of course. I'm sorry. Humor is God's great elixir. So thank you. Okay. And if I can have a nod, an ear pull or something, is that better? Good. Thank you. Thank you so much, Francie, for showing grace and helping rescue me there. Okay. The ABLE Act. Okay. And here we go. So Stephen Beck, it was renamed Stephen Beck Act because he single-handedly championed the cause, again, for 7 years. I helped get it through Congress, patterned after 529 college accounts. And there's your ABLE, nrc.org. The great website to visit with all details in different states about ABLE accounts. Legislation was passed 3 years later from 2014, and there were enhancements made to ABLE in 2017. Okay, so what does it take to be on the ABLE account train? You must be blind or disabled prior to the age of 26. In some cases, if a diagnosis was given prior to 26, and it will result in disability or death, such as spina bifida, hemophilia, muscular dystrophy, then those are examples where a person is eligible even if they are not considered totally disabled today. So we're looking for origins of this prior to 26. What does that mean? That means if your disability was as a result of an auto accident at age 30, not eligible. Fell down a flight of stairs at age 35, not eligible. I don't know, was in an auto accident at 40. Any of these things that are down the road. And you might say, why? Well, I didn't write the legislation, and there may be changes, more changes coming yet. However, the thought would be that if disability occurred later in life, you would have, prior to that time, had the opportunity to develop some sort of Social Security record, some sort of financial underpinning, et cetera. So this is geared primarily to situations where the disability was early onset, meaning one perhaps did not have an opportunity to build financial security, financial independence, et cetera. And also remember, it was patterned after 529 college accounts. And you might say, well, what does it have to do with that? Well, in a way, these 529 accounts, college accounts, were set up, and parents were, grandparents and so forth were funding them. So the question kept coming up, well, what can I do for my child or my grandchild that has special needs? You know, they may or may not be college bound. I don't want to be locked into having to use it for college expenses. And so that's also kind of the under age 26, meaning the younger type situation, similar to the 529 college accounts. So if age criteria is met and an individual is already receiving, meaning disabled prior to 26 and receiving SSI or SSDI, automatically eligible for ABLE. If the age criteria is met, meaning the disability onset or diagnosis prior to 26, but not receiving SSI or SSDI, then a letter of certification from a physician and or must meet the Social Security definition of disability, even if you're not currently drawing. So there is kind of a qualification criteria here. Okay, ABLE account limits. Well, the maximum annual contribution is $15,000 in some cases. So hold that thought for a moment, because it's not $15,000 for all people. That may seem unfair, but that was a part of the enhancement that came in 2017. 15,000 for everyone eligible, possibly more for some. Okay, and it's tied into the gifting limit. You may have heard of that before, 15,000 per person giving, per person receiving. That is the gifting limit currently in place based on federal tax law, enabling any individual to give to someone else without the need to file a gift tax return, without gift taxes, without taxes, period. So if that 15 goes up, then that may increase ABLE. We're not sure where that's going to go because of the new, because of the Biden administration may be making some changes. We'll have to see. As far as maximum account balances, 100,000 for individuals that are receiving SSI. So you want to keep that in mind. So if a person is receiving SSI, even though you can put in 15,000 a year, you're going to want to be careful about reaching 100,000, because when you get above 100,000, you have started a period of ineligibility for SSI. So we've not seen balances that large yet, because even at 15,000 a year, it'd be difficult to get there. But keep that in mind. If a person is not receiving SSI, or perhaps they're receiving SSDI instead, then the concern, of course, is for Medicaid. And for Indiana, the maximum is $450 for continued Medicaid eligibility, $350 in the state of Kentucky. If SSI recipient goes over, their ABLE goes over 100, SSI is suspended until it comes back down under 100. So you got to spend some money. Okay. That does not affect Medicaid. Medicaid's affected at $350, $450 as noted above. One ABLE account allowed per person. Please keep that in mind. Unlike 529 accounts where every grandparent and every parent can set up a different 529 account, not so with ABLE. Each consumer can only have a single ABLE account. The reason for that is so they can monitor the maximum in terms of how much is going into it, and they can also monitor how the account is administered and what it is spent on. Contributions can be made by anyone, a beneficiary, a family member, friends, a guardian, etc. So a lot of people can participate in contributing to an ABLE account. Okay, the enhancements. So tax and penalty-free rollover is one of the enhancements. So if an individual, let's say, had a part-time job and the employer was setting aside money into a 401k, and then because of COVID or some other reason, you lost your job, and now you have, let's say, $5,000 in a 401k, and because you've left employment, then Medicaid and SSI are going to want to consider that an available resource because you have access to it. So now, under the improvements that came with the 2017 enhancements, in most cases, that 401k could be rolled into the into the ABLE account, where it would not be considered an available resource. Rollover of certain retirement funds accounts may be possible upon termination, and it's on a case-by-case basis. So I'm always encouraging people, before we assume, to reach out to the appropriate ABLE authority, such as here in Indy, and it's the Invest ABLE folks. And I know Amy Corbett, who runs the ABLE program, and she does a great job. Okay, so in some cases, there's a credit available for qualified retirement savings contribution, and that may be possible. And then also the higher limit I talked about before, if one does have work and has earned income, that raises the ceiling. And the ceiling can be raised by up to $12,760. So actually it's true. If someone actually had earned income of $12,760, that would mean the overall total limit for that annual contribution would be $27,760. Okay, so if we're salting it aside, setting it aside, what can we spend it on? And the answer is all kinds of things. Look at the list. It's grown over the years, and ABLE accounts have got more flexible. So there's a lot of things that ABLE funds can be spent on, or withdrawals can be made. Okay, and withdrawals can be made by requesting reimbursement. Also, the Indiana Invest ABLE has a debit card option to access funds. Please keep in mind that with the legislation, because the consumer's money is welcome, in ABLE accounts, the state does have the right to impose a Medicaid payback. Indiana is not currently imposing it, but I think it's because Indiana's in better fiscal shape than most states. In the future, if that were to change, the state could step in and seek to reimburse themselves for Medicaid benefits afforded the consumer or the account holder from the time the account was set up, not from birth, but from the time the account was set up. For that reason, you want to be careful about other people's monies going into an ABLE. If we have a parent wanting to contribute, if we have grandparents wanting to help, et cetera, in many cases, it's better to use a special needs trust than an ABLE account, in which case there would be no Medicaid payback, no Medicaid lien. But for the consumer's own money, it can be a godsend. And in a moment, we will look at some examples of how ABLE accounts can come to the rescue. Again, I invite you to ask questions. Let me see if any have, let me check. See here, I'm attempting to access the chat. We're trying. Oh, nope, I guess not. Okay, very good.
There is something in chat. There is something.
There is. Okay.
Chat. Yeah.
All right.
Yeah.
I must have cleared it or something. I'm sure I did it wrong. Okay, here we go. All right. I'm okay. Yeah. Thanks. All right. Would child on autism spectrum meet ABLE eligibility criteria? Okay, that is a great question. So the answer to that question is the expectation that the child would in the future, based on what we know today, meet the Social Security definition of disability, or if there is, shall we say, not an expectation of full-time employment where they could work full-time, sustain or support themselves, live independently. So from a child's perspective, if a child has a diagnosis of being on the autism spectrum, if based on what you know today, the forecast is not toward full-time employment, post-secondary education, independent living, then that would be an indicator, yes, that they would be eligible to participate in an ABLE account. Next question was, can UTMA money be rolled over into an ABLE account? And the answer is UTMA money can go to an ABLE account, but in most cases, we liquidate the UTMA and then place the funds into an ABLE account. We can do a rollover on 529s. We can do a rollover on qualified funds. In most cases with UTMAs, we liquidate the account and then take those funds and place it into the ABLE account. Okay, wonderful. All right, so Indiana has Invest ABLE. So if you want to look up Indiana's plan, then it's Invest ABLE, otherwise kind of catchy, Investable, INVESTABLE, kind of catchy there. Invest ABLE. That's Indiana's plan. Down in Kentucky, they call it the Stable Plan. Kentucky Stable. I don't know, you'd think Kentucky had something to do with horses, you know, stable. Okay, that's my one attempt at humor tonight. Okay, all right. So, however, neither Kentucky or Indiana offer state-specific tax incentives. Now, Indiana does offer tax incentives on 529 college accounts. Kentucky does not, but for ABLE, neither state does. So the national tax advantages, meaning it grows tax-free, it distributes tax-free, but nothing that is state-specific. So as a result of that, some people are utilizing the Virginia ABLE America plan, which is through American funds, in which case, as opposed to you're setting up the account yourself and kind of self-help, an advisor such as myself can assist you in setting up the account for you. Also, American Funds has the Virginia 529 account, which is either number 1 or number 2, I think, in the country on the 529 side. So it only makes sense that they would also have an ABLE account through Virginia called ABLE America. And so that's very popular because as many people know, American Funds have excellent performance and again, are very, very, very popular. So you have the choice of do it yourself with Invest ABLE or Kentucky Stable, or if you want an advisor such as myself to assist you, we can utilize the Virginia plan through American funds.
Gordon,
Yes.
this is Tony. In a 529 plan, you can always change the beneficiary of that account. What happens if the benefactor of the ABLE account passes away and there's still money in the account?
Okay, so two things. First of all, what assets count as an available resource or don't? Currently, 529 accounts are not being counted as long as they are not a UTMA or a Uniform Transfer to Minor Act account. So if you do have a UTMA 529, the same as a UTMA savings account or investment account or anything UTMA, typically Medicaid and Social Security are going to want to count that as an available resource because like a heat-seeking missile, it's on track to fall under the control of the consumer or the individual with special needs. So those are a concern. Now, with regards to beneficiaries, so even the individual or the consumer with special needs can be the beneficiary of the 529. And it's not a problem as long as it's not a UTMA. And so I had a case just this morning where we were working with a family from Kentucky, and we have an expectation that the child who is currently in high school will go to college, and we have a 529 to assist with that college expense. So they are actually legally blind, and so they qualify through those channels as opposed to it being a developmental intellectual disability. It's the individual is basically blind. So that qualifies them for an ABLE account if they wanted, but they're expecting to be college bound, and so we have a 529 to help pay for those expenses. Also, I have another family who have a daughter who is at college with spina bifida. And so she's pursuing a degree, higher education. Her physical disability is what qualifies her for both SSI as well as an ABLE account, 529 account, special needs trust, et cetera. So I don't know, Tony, did I touch on something you were hoping to hear? Help me out.
Clarification, if you don't mind. If we have an ABLE account for our niece, and at some point in time she passes away and there's remaining dollars in that ABLE account.
Okay, when an ABLE account is set up, you do get to designate a beneficiary for the account. The state can step in if they choose to. Indiana is not presently doing that, but assuming they don't, then or they sign off or release the funds, it would go on to whomever is designated on the account as the beneficiary. Okay. All right. It varies by state plan as to what the minimum is, et cetera. Please understand, ABLE accounts do not work well where you're thinking, well, I'll set aside $100 every Christmas. We'll put the $100 of Christmas money in the ABLE account. So please keep in mind the fees with the ABLE accounts vary anywhere from $50 to $60 a year. So if you're putting $100 a year in, as you can imagine, you're not going to get very far. So ABLE accounts work best when it's 1,000 here, 1,000 there, that type of thing. Of course, keep in mind the SSI limit of the 100,000. And keep in mind that if it's grandparents' money or parents' money or anybody other than the consumer that has special needs or a disability, it may be better off going into a special needs trust where there is no Medicaid lien or no Medicaid payback clause. Special needs trusts are not that expensive. Again, we'll be talking about them next week. However, there are, and that's the ABLE National Resource Center we were talking about earlier. I do want to get to some examples of where ABLE can save the day, because I'm very pro-ABLE. It's just where it really makes sense to use it. So an ABLE account may not be the best vehicle if, again, may not be the best vehicle or account to use if inheritances, settlements, judgments, or contributions from family members or beneficiaries exceed the $15,000. So if it's too much money, it's not going to work with ABLE. Second, contributions are not coming from the individual with the disability, and therefore they could go into a third-party special needs trust, avoiding the Medicaid payback associated with an ABLE account. Or you have an age issue. The diagnosis came after their 26th birthday, such as a traumatic brain injury, Lou Gehrig's disease, ALS, stroke, multiple sclerosis, et cetera. Or the beneficiary cannot make financial decisions. So in which case, hopefully there perhaps would be a guardian or someone that could help, but that's a consideration. ABLE accounts can be used in combination with other vehicles such as special needs trusts. Okay, we're into some examples and we're right on time. We are doing awesome. If there are any more questions, let me know, please. Not okay. So we talked about what ABLE may not want to be used for. Now let's talk about what ABLE would be phenomenal for, would be absolutely terrific for. So better suited for small settlements, unexpected inheritances, or savings of the consumer. So think of it as a put and take or save and spend type of account. Examples where an ABLE account can be very useful. Example 1, grandparent dies, leaves $10,000 directly to each grandchild. Well, if we have one of the grandchildren with special needs, we've got a problem. $10,000 exceeds the $2,000 available resource limit for SSI, for Medicaid waiver services, et cetera. So what can be done with the $10,000? One option is to spend it. Just go on a spending spree and spend it away. It's a lot of money to spend that way. Or prepay final expenses, which is sometimes difficult to get excited about. So an ABLE account could be an option though. So if the executor of the estate's cutting checks and here comes the check for $10,000, then if you put it into an ABLE in the same calendar month it's received, then no harm done. An example number 2, incident at school results in a settlement of $15,000 for your child. And again, spend it, prepay final expenses, or ABLE to the rescue. And I've had 2 of these in recent years. I had one where actually a child with special needs went off to college. And unfortunately, the college they picked was not disability friendly. And the daughter that went off to the school, it was a small school, and they thought this is going to be great. And by the time it was said and done, she felt like she had been forced out. And so they got a hold of an attorney, and before it was said and done, the school offered to bring her back and give her a year's worth of free tuition, basically to replace the year that they totally screwed up. So that's a situation where, it was worth roughly $15,000. So that needed to be placed into an ABLE account to avoid it being a resource issue for Medicaid waiver services, et cetera. Example number 3, consumer has earned income and wants to save some of it for vacation, furniture, maybe additional schooling, vehicle, et cetera, while they still maintain their SSI, Medicaid waiver, et cetera. So in that case, they can take their earned income, save it to an ABLE account to save up for those things that they want to purchase. So definitely situations where ABLE can be extremely helpful. Okay, now things to consider with an ABLE account. We've kind of talked about what it can do. Now I want to be kind of careful as to what issues from a government benefit standpoint ABLE can help solve and what it can't. And this is really a time to ask questions if it's not clicking. So ABLE accounts within limitations can address resource issues by sweeping the inheritance, legal settlement, paycheck, 529, savings or investment account into an ABLE account. The consumer is back under the $2,000 resource limit. What an ABLE account won't fix are income issues. So keep that in mind. Resource issues, yes. Income issues, no. So let's look at examples. Example number 1, consumer age 22 is receiving SSI and has a part-time job, earning $500 a month. Placing his or her $500 paycheck in an ABLE account will not allow him or her to avoid the reduction in SSI, meaning putting the $500 paycheck into an ABLE account does not make it go away. For SSI purposes, they're going to forgive the first $85, the remaining $415 divided in half to $207.50. That means that their SSI benefit, which might have been $794 per month, would be reduced by $207.50 as a result of their earned income. The ABLE account will, however, help keep his or her bank, savings, and representative payee accounts under the $2,000 for continued SSI and Medicaid eligibility. So hopefully that kind of helps to see how it's a beautiful resource for dealing with resource issues, but it isn't going to avoid, SSI benefit reduction for earned income. Another example, consumer age 35 is receiving $500 per month in SSDI from their own employment record. That is, they worked their part-time job and qualified for Social Security disability. They also receive adult child benefits of $1,000 from a parent's record. That is a parent that's either deceased, disabled, or drawing Social Security retirement. They continue to work, earning $900 per month. They can save up to $25,800 per year to enable to keep countable resources under $2,000. Where does 25,800 come from? Well, 900 in earned income times 12 is 10,800. 10,800 plus the 15,000 is the 25,800. But this will not fix their exceeding the monthly max of $2,382 for disability Medicaid, meaning their Medicaid and their Medicaid waiver are at risk because they're at $2,400 a month, 500 and 1,000 for 1,500, 1,500 plus 900 for 2,400. So they should consider getting a Miller Trust. So a Miller Trust will save the day in that situation. So, oh well, just examples of what ABLE can do or not do. I got to tell you, there's a way to fix practically everything with special needs. It's a matter of how much you know and getting some help. It's all good. Special needs trusts are also a great option in the mix, and we'll be spending time on this next week. Special needs trusts typically are with the assistance of an attorney. And so if you're in Kentucky, then we get a Kentucky attorney to assist, otherwise an Indiana attorney. Special needs trusts are amazing. I think it's one of the greatest gifts we as a special needs community are ever going to see. The opportunity to set aside an unlimited amount of monies, either while we're living or through life insurance or our estate at our death, to help preserve dignity and quality of life for our loved one that has special needs. But we'll get more into special needs trust next week. So our special care program provides you with the opportunity to get help with all of the stuff we're talking about over these 3 weeks. A follow-up consultation to our series is free. We set aside typically 90 minutes for each family. The meetings can be in person in either the Indianapolis or Louisville offices, or it can be virtual, like by Zoom, like we're doing this evening, in which case you can be anywhere. I encourage you to take advantage of the free follow-up consultation because free is good and help is good. So free help is good. Okay, there's my contact information, so you can respond to any emails you've received from Jamie Sturchy, our parent advocate and relationship coordinator, or you can feel free to email me, gholmes@financialguide.com. My website is also listed because there are series that we're doing for other organizations. And so if you want to pass word along, please join us next Tuesday for Special Needs Trusts. And then if there are friends or others that you feel would benefit from these series, then I'm sure we'll do one again at some point for Special Olympics Indiana, and then as well as other organizations as listed on my website. Okay, now is the perfect time for questions, and I'm going to yield back the sharing, and so that I get to see all of you all. And I think I see a hand going up for Ann. Ann, help me out.
Yes. Okay, Gordon. So thank you for all this advice too. For my 22-year-old, I was thinking about starting an ABLE account because he also has a part-time job and gets SSI. We also want to be able to try to use it every 2 years, not including with COVID this year. We go to a medical conference, which we have to pay for hotel, travel, stuff like that.
Yeah.
Would we be able to pull money from the account to help pay for that?
Yes, absolutely. It can pay for all the expenses related to the individual. And then if it would physically be impossible for that person to attend without a person going with them, then you could have a conversation about paying for someone to accompany them if that's the only manner in which they would be able to attend.
Okay. I just want to make sure that we can use it for his medical conferences.
Yes, absolutely. So we talk about Disney World and taking cruises and having a fun time when we're able to do that again. But it can also be certainly educational. Absolutely. It could be
Now,
it can be horseback riding. It can be camp. It can, you know, it can be going to sporting events, even concerts, things that either enrich or enhance their quality of life. Having resources is wonderful. I tell you, I get so excited about this stuff because within my lifetime, the life expectancy for an individual with Down syndrome was 30. Now we're seeing 65 and 70. And there certainly have been advances in medical science, no question about it. But I think it has a lot to do with quality of life, you know, being engaged and having activities like Special Olympics Indiana and places to go and things to do. And maybe a little part-time job or volunteering and being a part of the community, that type of thing. So this special needs planning is all about quality of life, enhancing quality of life. The mission is not that dissimilar to Special Olympics in Indiana. You know, is to be brave in the attempt and to live as full a life as possible. You know, and having a child with special needs myself, I just think about the difference between, you know, food, shelter, and healthcare versus the full life and existence. And I'm just so thankful to be a part of the process of helping make that possible for people. Other questions? Yes, okay.
Gordon, if not, once again, we're calling in because of my niece, but would it make sense for my sister-in-law to include my wife as a guardian so that if something did happen to her, we would not have to go to court to rush through to try to get that guardianship?
Great question. I think it should be considered. It is a legal decision, and so it would probably be inappropriate for me to say go for it. But I think it should be considered because if who is currently guardian would list that individual or your wife or whatever as the guardian in their will, I was just making the observation you don't have to wait to the point of death. You could go to court and make it a co-guardianship situation for a much smoother transition. So I think it should be considered.
Okay, thank you.
Certainly. I so appreciate the people that have been willing to ask questions and engage with us this evening. That way, it's not just me talking the whole time. What a phenomenal group, and I see names that I recognize. So I'm so thankful for all of you. Again, feel free to respond to my email or Jamie's email. I do hope I get to meet with many of you virtually or in person as to how all of these issues apply to your situation, because I know it seems overwhelming and it's complicated, but you know, with help, we can get there. I know in the last 22 years we've worked with about 3,000 families, so we can get there. We can get it done. Other questions as we reach the hour of 8 o'clock and I turn back into a pumpkin or however that goes. I see smiles. You're very gracious to laugh at my humor. My wife reminds me repeatedly, don't quit your day job. Oh, goodness. Okay. Well, then I don't see anything else in chat. So I want to remind you next week, please, we're going to have a lot of fun with Special Needs Trust. You will be amazed. And so, yeah, please join in. Until then, God bless, stay safe, and stay out of the snow. Right.
Be careful going home.
Alrighty. Good night.
Bye, everyone. Thanks for coming.
Bye. Thank you.
Thank you.
Thank you so much.